Now, these 5 factors that we just studied may seem to suggest that a trademark must be used in India, or that trademark must be registered in India, or in fact that trademark must already be recognized as a well-known trademark before the registrar of trademark can accord it the special status of a well-known mark. That is actually not the case. Section 11 clause 9 of the Trademarks Act clarifies that there are certain factors which are not prerequisites for a recognition of a trademark as a well-known trademark. Yes, they may be important, but they are not prerequisites for recognition of a mark as well-known. These factors are that the trademark has been used in India. As we already discussed, some trademarks enjoy reputation in India without them being actually used. This is also relevant to the concept of trans-border reputation of a trademark. Trans-border reputation of a trademark means the reputation of a trademark that travels across borders of countries wherein a mark enjoys reputation in countries where it is not registered. You may recall that trademark registration gives territorial rights only, and by showing trans-border reputation, it may be argued that a mark enjoys well-known reputation in India even in the absence of any use of that mark in India. The second factor that the Trademarks Act cautions us against is that the trademark has been registered. Again, it may be helpful while arguing a case on whether a mark is well known in India to say that the mark is already registered, but it is not a prerequisite for such registration. The third factor that we are cautioned for is that an application for registration of the trademark has been filed in India. Again, this is not a prerequisite. Fourthly, that the trademark is well known in or has been registered, or in respect of which an application for registration has been filed in any jurisdiction other than India. Again, it is not a prerequisite to have a well known status from another jurisdiction, or to actually have registrations in other countries, or to have at least filed trademark applications in other countries. Now, all of these factors seem to suggest that reputation will be protected in a trademark even in the absence of a registration or application for the same trademark in India or abroad. And lastly, that the trademark is well known to the public at large in India. Now, this is a very interesting factor that section 11 clause 9 cautions us for. It says that the trademark may not be well known to the public at large in India. Now, let us understand this with the first requisite or the first factor under section 11 that we had discussed earlier for recognition of a mark as well known, which was knowledge or recognition by the specific segment of public. A reading of these two provisions where it is provided that it's knowledge of a specific segment of public and not the public at large, which is relevant for deciding whether a trademark is well known in India. Of course, it will be helpful if a trademark is recognized across sections of the society, but it is again not a prerequisite. Now, I had earlier mentioned that there are no specific guidelines for courts, there are no specific provisions in the Trademarks Act for courts to follow when deciding a trademark is well known. However, courts have developed over a period of time principles that they consider when they are deciding whether to accord the status of a well known mark to any mark. Now, these principles naturally are very similar to the principles set in the Trademarks Act for the Registrar of Trademarks. Now, the Delhi High Court in the case of Tata Sons versus Manoj Dodia laid down a few factors. I will quickly summarize those factors for your understanding, but you will also notice the striking similarity of these factors with those in the Trademarks Act. In this case, factors such as the extent of knowledge of the mark II and its recognition by the relevant public, duration of the use of the mark, the extent of the products and services in relation to which the mark is being used, the method, frequency, extent and duration of advertising and promotion of the mark, geographical extent of the trading area in which the mark is used, the state of registration of that mark, the volume of business of goods or services sold under the mark, the nature and extent of use of same or similar mark by other parties, the extent of actual enforcement by courts of the said mark, and actual or potential number of persons consuming goods or services being sold under the brand were listed as factors that may be considered while deciding the well-known status of a mark. One such factor is the nature and extent of the use of the same or similar mark by other parties. While we may not have a great detailed understanding of what this point refers to, but it may seem a little contradictory to the doctrine of blurring we discussed a while ago. As you may recall, blurring prohibits unauthorized third party use of a well-known trademark, but the courts have now said that third party use of a trademark which is unauthorized may be relevant to determining whether a trademark is well known or not in the first instance. Now, this gets us to another practical point on how are trademarks recognized as well known. Do you file an application for such a declaration? Do you approach the courts? Let us understand how this aspect is dealt with. Now, even if a court recognizes a trademark as well known, what happens after that? Is it an automatic generation of a well known status even before the registrar of trademarks? Practically, after a court gives a declaration of a well known mark, the proprietor moves an application before the trademarks registrar, who then records the status of the mark as well known in the register. Now, we discussed, yes, there are benefits to recognition of a trademark as well known, but how is a well known trademark enforced and these benefits realized by the proprietor of the trademark? For a registered trademark that is declared well known, Section 29 Clause 4 of the Trademarks Act is relevant. Now, while Section 29 Clause 4 does not specifically refer to well known marks, it refers to only marks with reputation. Hence, recordal of well known status is not mandatory when enforcing a mark under Section 29 Clause 4. Section 29 Clause 4 may also be seen as embodying the doctrine of dilution in India. Let us quickly study Section 29 Clause 4 of the Trademarks Act. This section provides that a registered trademark is infringed by a person who is not an authorized user of the trademark when it is used in goods or services which are not similar as those for the registered trademark, and the registered trademark has a reputation in India, and the use of the mark without due cause takes unfair advantage or is detrimental to the distinctive character or repute of the registered trademark. Here you will see that the doctrine of dilution is codified under Section 29 Clause 4 of the Trademarks Act. I must end with a word of caution. Trademarks that are recognized as well known enjoy far greater protection than others, and in some cases of abuse may lead to stifling of public expression, freedom of speech. Therefore, it is only in cases where a trademark is fit to be recognized as a well known trademark should such status be granted. I will now summarize today's module on well known trademarks. We started with understanding the meaning of what a well known trademark is, both generally and under the Indian Trademarks Act. We then understood the reason why some trademarks are given this special protection. After that, we understood the criteria which is considered while recognizing a trademark as well known. Now that we have understood the ammunition a well known status can accord a trademark, I will end with a word of caution. Because well-known trademarks give far more protection to trademarks than other trademarks are accorded, it is important to give such protection only to worthy trademarks. Otherwise, this will lead to a chilling effect in the market, where any use of a mark for unrelated goods or services will be curbed. It is also important to understand that such great protection may also stifle public expression or parody of a trademark. Thank you.